Patty. Read your chat. Ron?
All right, Mr. Weiner.
Good afternoon, Judge.
Afternoon. Ms. Tabram, can you move that camera up, please? This is cause number CR 19-207, State versus Ryan Emmanuel Smith for pretrial. You have Mr. Smith there?
I do, Judge.
All right, go ahead, Mr. Weiner.
So I believe there's a pretrial and also a bond reduction hearing today, Judge. Regarding the pretrial, we don't have any pretrial matters for the court. I am, and I wanted to explain to the court kind of our current situation. I know the court doesn't like waiting for other counties, but Mr. Smith was recently indicted in Henderson County for a drug offense. I have not received the discovery in that case. I have received an offer, I believe it actually came from Ms. Curry on this case. And I would like to get the discovery in Henderson County and see if there's a possibility of working out both counties at the same time. So I'm not really sure how the court would like to proceed, but I'd like to have some more time before we start looking at like a jury trial setting. But I don't have any contested pretrial for the court now.
Yeah, so typically what I do is if there's no contested pretrial, then I'll set it for a docket call to
Right.
give Vince and the state time to talk about resolving the case if they are, or requesting a jury trial or a bench trial. So, all right, court finds that there are no contested pretrial motions. The court will set Mr. Smith for docket call. Let's see. You said he has been indicted in Henderson County, but you don't have the discovery there yet.
That's correct, Judge.
Do you know about how long it takes to get discovery upon indictment?
He is set for arraignment on July 2nd. It would be unusual if we didn't have it by that date.
So you're wanting something after July 2nd for docket call?
If possible, Judge.
Is there any objection from the state?
No objection, Your Honor. Thank you very much.
All right, Mr. Weiner, I can set it July 9th or 11th.
Let's go. Oh,
Or
sorry.
Go ahead. I interrupted you. Go ahead.
9th is perfectly fine, Judge.
All right, court sets Mr. Smith for docket call on July 9th. And time will be determined by whether he's on bail or in jail. So now the court will take up Mr. Smith's motion for bail reduction. Do you want to call your client today, Mr. Weiner?
For the limited purposes of bond reduction, yes, sir.
All right, Mr. Smith, you're going to be called for the limited purposes of bond reduction. If you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor, I do.
All right, thank you. You can lower your hand. Just speak up loudly and clearly for me. Go ahead, Mr. Weiner.
Please go ahead and state your name for the record.
My name is Ryan Emmanuel Smith,
Okay, and where did you grow up, Ryan?
in West Texas, up by Amarillo,
And how far did you go in school?
12th grade,
And where did you attend school at?
Hereford High School.
And you ultimately dropped out but got your GED, is that correct?
That's correct.
And what have you been doing for work up until you were arrested?
I'm a welder by trade, been doing it for 15, 18 years.
You're self-employed but do welding jobs.
Yes,
And if you were to make bail on this case, this $200,000 bond is the only thing that's holding you in custody right now, is that right?
that's it.
And so if you were able to make that bail, you'd go back to work as a welder, is that right?
Absolutely.
And before you were arrested, where were you living?
Payne Springs in Henderson County.
And you lived there with your girlfriend, is that right?
Yes, my girlfriend.
And did y'all have children between the two of you?
Yes, we have 2 girls and she's 5 months along and carrying our son now.
And so you being incarcerated, not being able to provide for her, especially being pregnant and taking care of 2 other kids has been very difficult. Is that true?
It's posed a huge problem.
Okay.
Huge problem.
And you don't have any banking accounts in your name, no checking account, no savings account, anything like that?
No, I do not.
And you don't own the truck that you have, is that right?
No.
Okay. And what we're asking for today is that the court reduce your bond to $25,000, is that right?
Yes, sir.
And you understand that if the court were to lower your bond and you made bail, that he could impose numerous terms and conditions.
Yes, I do, and I'd be willing to conform to whatever you should ask if you do grant it. I don't mind coming up here. I don't mind doing your analysis.
Even if he wants you to come up and report once a week and take a drug test every single week at your own expense, you'd be willing to do that. Is that right?
I'm self-employed, so it don't pose an issue with work availability hours or it sure wouldn't be a problem.
And you have access to a vehicle even though you don't technically own one to get to and from, is that right?
Yes, I do.
Okay. Judge, that's all I have. I pass the witness.
State your witness.
Thank you, Your Honor. Mr. Smith, you have previously been convicted of felonies in the past. Isn't that true?
I'm gonna object to that. I have no problem with the state reciting the criminal history as they believe it to be, but I don't believe my client should be subject to answering questions for potential enhancement purposes.
I'm just asking for acknowledgement of the two priors, Your Honor. That's really the question.
I'll sustain the objection, but allow the state to disclose to the court any evidence it has regarding 17-151.
Thank you, Judge.
Now, Your Honor, we do have certified copies of convictions from January 6, 2005, in which he was sentenced to 6 years TDCJ for second-degree manufactured delivery controlled substance group 1. In addition to that, there's also another matter where he was sentence was imposed on December 20th, 2004 for 6 years Texas Department of Corrections, possession of controlled substance as well. However, that one also indicates a robbery as an offense. So I just asked the court to take that into account. Now, Mr. Smith, you also failed to appear once before in this case, did you not?
Judge, again, I'm going to object. He's asking questions, asking him to admit his guilt in a pending offense.
All right, court's going to sustain the objection, but I will take judicial notice of the bailiff certificate filed in this case.
I appreciate that, Your Honor, and I believe the warrant was issued. So under those circumstances, while the state would have no objection to consideration on that $200,000 bond, we believe $25,000 may not be an appropriate bond under these circumstances. I pass the witness.
Mr. Weiner,
Nothing else, Judge. His argument.
any evidence from the state?
No, Your Honor. Thank you.
All right, go ahead, Mr. Weiner.
Judge, I just point out that based on what I heard, if I heard it correctly, those offenses were almost 20 years ago. But I do appreciate the state's concession that they're not necessarily opposed to the court lowering the bond, but not necessarily going as low as what I request. I just ask that you do what you think is appropriate and grant the reduction, Judge.
All right, thank you, Mr. Weiner. Mr. Hernandez?
I just rest on the record, Your Honor. Thank you.
All right, then based on the evidence before the court does find that Mr. Ryan Emmanuel Smith was indicted in this matter, posted a $100,000 bond on or about June 22nd, 2023, failed to appear in this court as ordered. A KPS was issued for the arrest of Mr. Smith. So at this time, I'm going to find that Mr. Smith is a flight risk and that $25,000 is an insufficient bail amount to ensure the return of him to the jurisdiction of this court. So the motion for a bond reduction is denied.
Understood, Judge.
All right, we'll see y'all back on July 9th.
Thank you, Judge. That's all my business. May I be excused?
Yes, sir.
Thank you.
Tim Ram, do we have anyone else that's ready?
I think still needs a few minutes. I think we do have Mr. Story on Zoom.
All right.
But we also
Who is he?
Kiara Coons, but we do not have her in here. We can get her.
Yeah, if you don't have anyone else there that's ready, go ahead and bring in Ms. Kuntz and I'll bring in Mr. Shorty.
Your Honor. I'm sorry. Please.
Give me just one moment while I bring Mr. Story.
Okay.
Hello.
All right, good afternoon, Mr. Story.
Hello, sir.
This is cause number CR 23-94, State of Texas versus Kiera Lachey Kuntz. We're set for pretrial. Any announcements, Mr. Story?
We are not ready. We're still working with the district attorney's office to receive discovery. I did receive an email not too long ago this morning, and I need to talk to the provider for that service. So that's where we are today.
What does that mean? You got to talk to the provider of the service. What does that mean?
I follow the normal instructions that they have for their provider, the one who supplies the portal for the discovery. It seems to not be working, is what the DA's office is telling me. And so they're referring me over to their provider to have a direct conversation with them and to enable us to access that discovery.
So has this been an issue that's been persisting for the last couple of months?
Well, our first appearance was, I believe, about 30 days ago. I'm not looking at my calendar. And Mr. Hartwell, I believe, was in trial during the last month. And we were finally able to contact each other last week. And that's when we started working on this. So.
Okay. All right. Court's going to reset Ms. Coons for an additional pretrial hearing. Allow Mr. Story to get the discovery issues lined out. If you have your calendar with you, Mr. Story, I want you to look at it.
Yes, sir.
Let's look at either June 13th or June 18th. It's one of those days better for you?
I believe the 13th would be
13th.
better.
Okay. All right. Court sets Ms. Coons for an additional pretrial on June 13th at 1:30. If Ms. Coons ever makes bail in this case, then her court date will be the same date, but it'll be in the morning at 9 a.m. If she's in custody, then it will remain at 1:30.
Understood, Your Honor.
And Your Honor, just for purposes of the record, we've been talking with LGS. It appears that the issue has been resolved. So as soon as they can get with Mr. Story, they should be able to get him access to the discovery portal. So I expect that hopefully by the end of today, certainly within the next day or two. But I just wanted to let Mr. Story know and the court know that Miss Melton's been on the phone with them most of this morning, making sure that all the issues are resolved on our end for that portal access.
Is it a specific issue to Mr. Story and his technology, or is this something he's been having all defense attorneys?
Your Honor, I don't know if it's been affecting all defense attorneys, but it is a more generalized issue. If memory serves, it had something to do with the servers. So I know it has impacted at least a couple of attorneys. I don't know how wide ranging it is, but it appears they've resolved that issue.
All right. Thank you, Mr. Harwell. All right. Thank you, Mr. Story. We'll see you back on June 13th.
Thank you, Your Honor.
You're welcome.
Mr. Manning needs to talk with the state, and so can we take about a 15-minute recess?
What about Lindy Delaney? Does she have an attorney in?
We haven't brought the females in yet.
All right, then we'll stand in recess, give Mr. Manning time.
Mr. Roll, are you married person?
Your Honor.
All right, Mr. Manning, who are you ready on?
Judge, ready on Mr. Ehrenfeld. He was from Tuesday's docket.
Yeah, we're doing a plea today, correct?
That's correct, Judge. And
All right.
Judge, before we begin, I was just gonna let you know, Mr. Ehrenfeld is making a request, based off his, I'd ask the court to take judicial notice of the
Do you
court's
want,
file.
do you want this on the record?
Oh, right, sorry, Judge.
Yeah, I mean, do you want it on the record?
I do.
Okay, then the court calls cause number CR 23-106, State of Texas versus Kevin Max Aaronfield. Go ahead, Mr. Manning.
Thank you, Judge. Judge, I'd ask the court to take judicial notice of its case file, particularly noting the finding of Mr. Ehrenfeld's indigence, both currently and previously. Judge, I'd also note that Mr. Ehrenfeld has been in continuous custody since he's been in continuous custody for 595 days since he was last here in Van Zandt County. He has been down in Johnson County where he picked up a new charge and resolved his business down there. Judge, based off of that and his continued homelessness, we would request that the court cost and reimbursement be waived in his situation, as I think he qualifies under his extenuating circumstances for time served based on the length of time that he's been incarcerated, as well as the little amount that is owed. We'd ask that those be waived on Mr. Ehrenfeld's behalf. In the alternative, if the court's unwilling to waive those and give him time served credit for those, we would request that he have a capias issued immediately, as he is making the court aware he's unable to pay those. He has no job, no identification, no transportation, no residence, and no connections to the state. He'd asked that he be allowed to sit out the $209 court cost, as well as the reimbursement from his previous representation of $565, and ask that that KPS be issued at the conclusion of our hearing today.
Did you say previous $565, or the judgment here says $65 reimbursement? Should that say 565?
Judge, we're proceeding under 1244A, and my only guess is that because he's not going to state jail, but serving in county time, they just took any prior cost and reassessed those as balance of financials. Mr. Ehrenfeld was able to point that out to me, that it looks like that may have been from the previous representation for my court appointed attorney's fees.
Guess I'm still confused though, because if he had previous court-appointed attorney fees, it would be more than $65, correct? That's correct. He would have,
That's
he
correct.
would have 500 probably or more, right? My question is if this is the balance of what he owes, why is it only $65 if he owes not only for this case for attorney fees, but also for a previous case for attorney fees? That's what I'm confused about.
And
This
that's
looks
what
like it could be paid down or something.
That's what I'm saying, judges, is when they go to prison, they are not, certain fees or restitution or reimbursement is not assessed against them. And so my only guess is that when we switch the paperwork to 1244A, which I think you have the prior paperwork that is just a state jail TDC sentence, when we switch that to 1244A, so that he wouldn't have to be housed here, catch chain, go down there, and then be pulled back for capias or some other proceeding. That's, I think, where the 565 came in.
Okay, good. Because the paperwork I have is, as you say, a state jail, no 1244A. It was going to be 12. It was going to be 12 months state jail with $65 reimbursement fees, $290 court costs, 365 days in jail. But now you're saying it's a 1244A. What was the recommendation now?
Judge's recommendation now is that upon a plea of true to the state's motion to adjudicate the defendant's guilt be adjudicated, community supervision revoked, punishment assessed under 1244A at 1 year in the county jail with credit for time served, and a balance of financial obligations.
Where is Mr. Ehrenfeld? Is he going anywhere after this?
Yes, Judge. We believe that he'll be going to Rains County.
And he's already resolved his Johnson County charges?
Yes, Judge.
And what does he have pending in Rains County?
Judge, he was on probation there as well.
But I've already had that dismissed. Go back there. Both probation.
He's on probation in Rains County?
Yes, Judge.
And that was, I guess, pending the whole time that this was going on, our Van Zandt County charge?
Judge, these charges, the Rains County and this charge arose simultaneously. And so those were tracked at about the same time. He got the probation in Rains County prior to getting the probation here in Van Zandt County.
All right, I'll take that under consideration. I'll let you know at the conclusion of the hearing.
Okay, thank you, Judge. With that, Judge, we're ready to proceed on under the plea as it's been stated.
All right, Mr. Ehrenfeld, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right,
Yes.
you can lower your hands. All right, Mr. Ehrenfeld, I need to go over a few things with you. First and foremost, it appears to the court that you were before the court on May 9th of 2023. You pled guilty to a state jail felony offense of obstruction of a highway or passageway for emergency vehicles, and the court heard the evidence on that day, followed the plea agreement that you reached with the state, followed the state's recommendation. The court did not convict you. However, the court did defer a finding of guilt, place you on community supervision for a period of 4 years. And it was during that period of your supervision that the state filed its motion to adjudicate your guilt and revoke your community supervision. They filed that on June 13th, 2023, roughly a month after you were placed on community supervision. Have you had enough time to review that motion with your attorney, Mr. Manning?
Yes.
Well, the question was really for you. Could you not hear me?
Yeah, I thought you were asking him, Your Honor.
Yeah, no, I'm asking you.
Yes.
Have you had enough time to talk with Mr. Manning about this motion and everything that's gone on in this case?
Yes, I have.
Okay, and do you feel like you've had enough time to talk with him to determine what your legal rights are and that you fully understand everything as part of your plea agreement?
Yes, sir.
All right, Mr. Manning, do you believe Mr. Ehrenfeld to be competent?
I do, Judge.
And you've explained to him the rights that pertain to this case?
I have explained those to him, Judge.
Mr. Ehrenfeld, are you pleased with Mr. Manning and the work he's done for you?
I am.
All right. And Mr. Manning, does Mr. Ehrenfeld waive the formal reading of the state's motion?
He does, Judge. I would like to clarify that the case or the charges that were alleged in states, there's only one violation that is a new charge out of Johnson County. That charge was actually dismissed, and he resolved that case in another way. We are proceeding we're proceeding on the premise that he did pick up a new violation while he was on probation, Judge. Really, in my conversations with Mr. Ehrenfeld, his willingness to wrap up this probation is that he just sees now that he's not a good candidate for probation based on the fact that he doesn't have a stable living environment. The veteran services that he was told he was going to get were not provided to him as promised in Dallas County. And he was really left to fend for his own, unable to keep up with his probations. And so due to him recognizing he's not a good candidate for probation at this time of his life, he wishes to go ahead and have the court assess punishment as it's been laid out.
So he is pleading true to count one.
Yes, Judge, not in the form that it is, but he is confessing that he did commit a new offense while on probation, just not burglary of a vehicle.
What is he admitting that the record's going to have to be clear in count one's alleging a burglary of a vehicle. If he's confessing to something different, then that needs to be amended and it needs to be as part of the record written in there. What is he pleading true to if it's not burglary of a vehicle?
Judge, that would be criminal trespass, and I have the paperwork. Mr. Ehrenfeld gave me that paperwork. I can provide that to the court to show that he has in fact resolved that case in Johnson County.
Was he arrested for criminal trespass at all in Johnson County?
No, Judge.
All right, so is the state making an oral motion to amend its motion to adjudicate to amend count one to be a violation of his community supervision by committing a criminal trespass on or about May 31st of 2022 in Cleburne, Texas?
Your Honor, if I have just a moment, and I'll have an answer for that momentarily.
Okay, if there is no objection, Mr. Manning, then what I'm going to ask you to do is interlineate there on count one. If there is no objection, then the court's going to grant that amendment. Then I would ask that you wait and we hear what the objection is, if there is one. And then if not, then we interlineate and we insert criminal trespass language into count one.
Yes, Judge.
While we're waiting on the state, in considering the reimbursement fees owed to Van Zandt County and the fines and fees, Mr. Manning, can you tell me more about Mr. Ehrenfeld's veteran status, number one, and what his plan is moving forward as far as work, disability, income, things of that nature?
Yes, Judge. So if you recall, last time we were here, when Mr. Ehrenfeld was entering into the plea, he made a request, so he set a record out that as part of his plea in Rains County, they had waived fines, they'd waived court costs.
Waived everything and dropped my fees down to $15 a month, Your Honor.
Supervision fees down to $15 a month based off of his indigence, as well as him going to Dallas County to receive services from the VA hospital in Dallas. When Mr. Ehrenfeld got out of Van Zandt County and made his way on his own to Dallas,
They took me there.
when he arrived, he was went through multiple days of interviews and in processing for the VA program. He was sent to a shelter that they contracted with, and where he slept in an open room on concrete floors, waiting for placement. He was unable to be placed in a more permanent facility there, and so there he was able to come in contact with a acquaintance who was able to give him work as well as provide transportation for him. It was at that point in time that he ended up in Johnson County, and that's where he got picked up on the criminal trespass. Mr. Ehrenfeld does not have an identification. He does not have any family in the area or any resources. And my belief is from my conversation with him, that is, once he completes his business here in Texas, he plans to leave the state and go to a portion of the country where the VA hospitals are working a little more efficiently and appropriately to handle his situation and get him the help he needs to get back on his feet.
What branch of service did Mr. Ehrenfeld serve?
US Army,
And when did you serve?
during Desert Storm, 89 to 92.
Thank you, sir. Appreciate your service. Mr. Hartwell, do you have any response to the oral motion? Do you have any objection to amending the count in the state's motion?
Your Honor, not necessarily an objection, although I'd feel a little bit more comfortable if there was a judgment to attach to it, or even an affidavit written by Mr. Ehrenfeld. Just since the motion was, I'd feel a little bit more comfortable if there was some sort of supporting documentation to attach to the judgment along with the interlineation.
You have
Judge,
anything
and
to that
Mr.
end?
I'm sorry, Judge.
I said, do you have anything to that end?
Yes, Judge. Mr. Ehrenfeld's paperwork is back in his cell, and my copy is back at my office, where I'd scanned it in. If we would like, we can recall the case, and I can get a copy to the court and to the DA's office for their consideration.
And exactly what is this document?
It's going to be a judgment for the plea to the criminal trespass, and I believe the dismissal.
They filed the correct paperwork for dismissal for the theft because of amount of fee.
Okay.
And Your Honor, I'd be fine taking Mr. Manning's word for it and proceeding right now and just attaching that to the judgment at some point before it gets finalized.
Okay, very well. And I'm fine with that as well, Mr. Manning. We'll ask Mr. Ehrenfeld to retrieve that from the jail so that we can make a copy of it. We'll make an additional copy and we'll attach it to work here.
I'll send that back with Ms. Abraham.
All right, and so the defense has made, correct me if I'm wrong, Mr. Manning, you're making a motion that we amend count one of the state's motion to adjudicate to reflect that the defendant violated condition A of his supervision in that on or about the 31st day of May 2023 in Cleburne, Texas, he did then and there commit the criminal offense of criminal trespass. I'm going to believe that's probably against Ellen and Shelby. Is that correct?
Yes, Judge.
All right. And Mr. Hartwell, for the record, no objection from the state.
No objection, Your Honor.
All right. Court will grant that trial amendment. Court will order that count one be interlineated and changed to reflect the plea of true to the criminal trespass. Court will order Mr. Ehrenfeld to provide a copy of that judgment to support that. All right, so I believe that we're at the point in the proceeding, Mr. Ehrenfeld, where I'm going to ask you at this time, understanding that the plea agreement in your case, let's go over that again. You're originally charged with the state jail felony offense of obstruction of a highway passageway for emergency vehicles. That is a state jail felony. However, the plea agreement today would be to a lesser punishment under section 1244A, which if the court followed the plea agreement, you would still be convicted as a felon for that offense. However, you would be punished with misdemeanor confinement, a range of punishment not to exceed 365 days, to which the state's recommending that you do receive that maximum of 365 days or 1 year confinement in the county jail, with you receiving credit for 365 days of time already served and the balance of your financial obligations. Understanding that the court's going to take that under consideration, your balance of financial obligations. Is that your understanding of the plea agreement, Mr. Ehrenfeld?
Yes, sir.
All right. Understanding that, then I ask you, how do you plead to count one as amended in the state's motion to adjudicate? Is that count true or not true?
It's true.
And okay, court will accept the defendant's plea of true to that count. Mr. Manning, Or let me ask you, Mr. Aaronfield, has anybody threatened, forced, or pressured you to plead true to that count?
No, sir.
All right, court will accept the defendant's plea of true to count one. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of true?
No objection to state's one.
All right, that is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
Judge, in consideration of Mr. Ehrenfeld's request regarding his court costs and reimbursement, if you would like, I can provide, when I provide Mr. Abraham a copy of the Johnson County judgment, I can also provide a copy of his jail credit as it exists both here and possibly for Johnson County as well, where the warrants attached and all that stuff.
Okay, well, let me ask first, did Johnson County waive their fines and fees?
I'd have to ask my client.
On the paperwork, yes, sir, they did. It was included in my time, sir.
Okay, I'll tell you what, let me get all of that paperwork and review it before I make a final decision, but I will do that today. Once the paperwork gets back over here, then I will make that decision and I'll communicate with you, Mr. Manning, and you can, and we'll get message to you as well, Mr. Enfield.
Thank you, Judge.
All right, so at this time, based on the evidence, the court is finding that there is reason to believe and evidence to support that Mr. Ehrenfeld has violated the conditions of his community supervision. Court finds that count to be true. The court follows the plea agreement and the state's recommendation. The court adjudicates him, convicts him of obstructing a highway or passageway for emergency vehicles. The court revokes his community supervision, assesses his punishment under section 1244A of the Texas Penal Code at 1 year confinement in the Van Zandt County Justice Center. The court gives him credit for 365 days towards that incarceration. Further, the court orders the balance of his financial obligations, and the court will consider giving him credit for those upon further review of the evidence. All right, Mr. Ehrenfeld, you're hereby remanded to the custody of the sheriff, where you carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. Who's next?
Judge, ready, next ready on Mr. Ross.
All right, Mr. Ross, if you'll come forward. This is Jatavian Darnell Ross, CR 24-63 for pretrial. Go ahead, Mr. Manning.
Judge, we have a plea agreement in this case.
All right, Mr. Ross, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Your name is Jatavian Darnell James Ross, is that correct?
Yes, sir.
Mr. Ross, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the legal work he's done for you?
Yes, sir.
Do you feel like you've had enough time to go over all of the paperwork, have all of your legal questions answered?
Yes.
Is there anything about your plea agreement that you do not understand?
No, sir.
And you've gone over your conditions of community supervision as well, correct?
Yes, sir.
All right, you are charged by indictment with a third-degree felony offense of evading arrest or detention with a vehicle that does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison. Also carries an optional fine not to exceed $10,000. I see the plea agreement in your case is that you would plead guilty to that crime. In exchange, the state's recommending that the court assess your punishment today at 5 years confinement in prison, but also that the court suspend that sentence and place you on 5 years of community supervision, along with a $1,000 fine, $290 court cost, and $520 in reimbursement fees. In addition, the state is going to be asking the court to dismiss 2 unfiled charges: possession of marijuana between 4 ounces and 5 pounds, and also a reckless driving. Is that your understanding of the plea agreement, Mr. Ross?
Yes, sir.
Mr. Manning, do you believe Mr. Ross to be competent?
He is, Judge.
And you've explained to him his rights as they pertain to this case?
I have, Judge.
And you believe that he's entering into this agreement intentionally, knowingly, and voluntarily?
I do, Judge.
All right, Mr. Ross, how do you plead to evading arrest or detention with a vehicle?
I plead guilty.
Are you pleading guilty because you are in fact guilty of committing that crime?
Sorry.
And has anybody threatened you, forced you, or pressured you to make that decision?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
Judge, let me make sure. I don't believe that we got a stipulation of evidence. Let me check. I had a couple sets of paperwork here. Hold on one moment. Apologize, Judge.
Do you have it?
We do, Judge.
Any objection to that being admitted in evidence?
No objection, Judge.
All right, the stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
Rest and close, Judge.
Mr. Manning, would you mind presenting that stipulation to the court or putting it in front of the camera, however you want to do that? You'll just hold that still. Thank you, sir. All right, the court, having reviewed the stipulation of evidence, finds that there is sufficient evidence to convict Mr. Ross of this offense. Court does follow the plea agreement. The court convicts Mr. Jatavian Darnell James Ross of evading arrest or detention with a vehicle, a third-degree felony, assesses his punishment pursuant to the plea agreement at 5 years confinement in the Texas Department of Criminal Justice. The court suspends that sentence today, places him on 5 years community supervision, orders him to pay a $1,000 fine, $290 court cost, and $520 in reimbursement fees. In addition, the court does dismiss under section 1245 as part of this plea agreement, unfiled DA causes relating to possession of marijuana and reckless driving. Mr. Ross, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. After that, the probation officers will give you more information. Who's next, Mr. Manning?
Judge, next we're on Mr. Leonardo Rosas.
All right, cause number CR 21-391, State versus Leonardo Daniel Rosas. And we are set for docket call, I believe.
Judge, yes, we are set for docket call. We reached an agreement. Just before we begin, though, I would note that in going over the paperwork this afternoon with my client, the judgment showed that this was brought by a complaint. However, I believe, if my memory serves me correct, that this was actually done by indictment. Other than that, I believe we're ready to proceed.
What are the terms of the agreement?
Judge, the terms of agreement are that a fine will be deferred, punishment assessed at 3 years community supervision, and a fine of $1,000, as well as $180 restitution.
Court cost $290,
Yes, Judge.
$180 restitution, you said?
That's correct, and reimbursement in the amount of $585.
You know what, I do have it here. Just did not see it. This Abraham had it for me, I just did not see it. All right, also see an alias on here. He's also known as Christopher Robles, is that correct?
Judge, I believe that was the name that was used at the stop, and that was the name that the lab was submitted under.
Your Honor, I did ask that the paperwork reflect that AKA as well. I don't know if that made it over there as well.
It's reflected on the judgment.
Okay.
Mr. Manning, is there any objection to that alias?
Judge, I just note that they did fingerprint Mr. Rosas while he was in custody, and they ran that fingerprint back up and against the database, and they came up with his name as Leonardo Rosas, not Christopher Robles.
Did your client use that name though as an alias?
Yes, Judge.
All right, Mr. Rosas, if you'll raise your right hand, sir, I'm going to place you under oath. Mr. Rosas, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, lower your hand. Just make sure you speak up loudly and clearly for me. Your name is Leonardo Daniel Rosas, is that correct?
Yes, sir.
And Mr. Rosas, during the course of this case, did you hold yourself out to be identified as Christopher Robles as well?
Throughout the case.
At the time of the investigation, the time that you were arrested?
Sir.
Okay. And Mr. Rosas, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Yes, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's legal representation?
Yes, sir.
Feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over today that you do not understand?
No, sir.
All right, Mr. Manning, do you believe Mr. Rosas to be competent?
He is, Judge. He's been able to participate as defense, ask appropriate questions, as well as review the discovery as necessary.
And do you believe he is entering into this intentionally, knowingly, and voluntarily?
I do.
Have you also explained to Mr. Rosas the advantages and disadvantages of a deferred adjudication plea?
Yes, Judge, I've explained to him that if he's unsuccessful, he will face 180 days up to 2 years in the Texas Department of Criminal Justice State Jail Division. And that will be done on a hearing, not to whether he committed this offense, but whether or not he violated the conditions of the court's probation.
Thank you, Mr. Manning. All right, Mr. Rosas, you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1, less than 1 gram. That does carry a range of punishment, as Mr. Manning said, not less than 6 months confinement in prison and not more than 2 years. In addition, a fine of up to $10,000 could be imposed. I do see the plea agreement in your case. Upon your plea of guilty, the state's recommending to the court that the court not convict you of that offense, that the court defer a finding of guilt, that the court place you on 3 years community supervision, order you to pay a $1,000 fine, $180 restitution, $290 in court costs, and $585 in reimbursement fees. Is that your understanding of the plea agreement, Mr. Rosas?
Yes, sir.
All right, understanding the plea agreement and the range of punishment, at this time, Mr. Rosas, how do you plead to possession of a controlled substance in penalty group 1, less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And Mr. Rosas, has anybody threatened, forced, or pressured you to plead guilty?
No.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No objection to state's one.
States 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
Resting closed, Judge.
All right, court's going to review states 1, the stipulation of evidence. All right, court finds that there is sufficient evidence to convict the defendant of this offense. The court does follow the plea agreement. The court defers the finding of guilt, places Mr. Rosas on community supervision for a period of 3 years, orders him to pay a $1,000 fine, $180 restitution, $290 in court costs, and $585 in reimbursement fees. Mr. Rosas, you are hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. You're going to step over to be fingerprinted, and then the probation officers will give you more information. All right, who's next, Mr. Manning?
Judge, ready now, Mr. Michael Davis.
Mr. Davis, if you'll come forward. This is cause numbers CR 22-176, CR 22-120, I'm sorry, CR 23-124, CR 23-125, CR 23-149. I believe that we're set for docket call. Go ahead, Mr. Manning.
Judge, we've just recently been extended an offer that is significantly less than what was previously offered. However, my client and I have not had an opportunity to go over the particulars of that offer and how the effects of parole would play into a plea as that has been extended. We request additional short setting for him to consider the offer that's been made, as well as to weigh that as to whether he wants to proceed on some or all of these cases.
Not really inclined to grant that to Mr. Davis. I show that we're set for final docket call today. Is that not correct?
Judge, we're set for final docket call on three of the 4 cases. However, they did indict a new case that we just got to docket call on in CR 23-149.
And you said that he's received an offer that is less than the other offer that he went into this hearing expecting to have.
Yes, Judge, the state made an offer in a timely fashion, but I was unable to communicate that offer to Mr. Sprouse until today. The offers, sorry, Mr. Davis today. I got several offers recently, Judge, and Mr. Davis was one of those that I was unable to get to speak about.
How long do you think it would take? Can we just recall his case and give him more time today? I mean, if he came into the hearing thinking he's going to get X and now the offer is less than X, he should have already made a decision as to that.
Sure.
Or if it gets better, then.
Sure, Judge. Well, the original offer was basically a non-offer in terms of parole eligibility, the length of time, and on what charge it was going to be assessed on. And so now he's actually having to weigh and consider the evidence against him in multiple cases versus the time that's been offered. Additionally, Judge, while he's been in here, he's very diligently been working as a trustee. And my understanding is that Sheriff Carter has spoken on his behalf to the DA's office about Mr. Davis and possible plea agreement. And so, Judge, I'd just like an opportunity maybe to, I am unaware as to what the sheriff has said on behalf of my client, nor am I aware at this time of whether or not I have advised my client as to particular parole eligibility requirements of the sentence that he would take under this new offer.
All right, then I'm going to grant him, I guess, a final docket call on May 16th. He's got 2 weeks to make his decision.
Yes, Judge.
That's going to be in every case.
Hey, Judge.
You're welcome, sir. Who would you like next?
Judge, next we can have Mr. Mark Del Cambry.
Mr. Del Cambry, cause number CR 24-4 for docket call. Go ahead, Mr. Manning.
Judge, we announce ready and request setting on the jury selection docket.
Okay. And Mr. Del Cambry understands the court's policy on not accepting pleas after placement on the jury docket. Is that correct?
Judge, I believe we've discussed that previously, but Mr. Del Cambry, you understand that if the offer that's been extended to you at this point in time will be withdrawn, and the court may not allow any future plea offers to be tendered for his consideration past this point in time. You understand that?
Yes.
You understand that basically the only way this case ends is either by a jury trial, a bench trial, or dismissal from the state.
Yes.
Okay.
Just for the record purposes, what offer was extended and rejected?
Judge, I did not write that. It was for time, and based on the facts, my client wasn't interested in proceeding with that offer.
Okay. Mr. Hartwell, can you provide that to the record?
Yes, Your Honor. It was for 3 years TDCJ and a lifetime protective order.
All right. Court knows that an offer has been made and rejected by the defendant. Court will place Mr. Del Cambray on the court's jury trial docket. We'll do that beginning Monday, May 20th. So, Mr. Del Cambray, so that you understand how it works, placing you on the docket that day, your case is not going to be tried that day. There are other trials ahead of yours. However, you're going to remain in the system until your case moves up to the top. Once your case gets into the top 10, I'll notify Mr. Manning. And then we'll know, once it gets to the top 10, we'll know really about when your case is going to be tried. But it's just a process that we have to follow. So I'm going to start you on May 20th. And then when your case gets up there, then I'll alert him. We'll get you in for trial.
Okay, thank you.
All right, you're welcome.
Sorry, thank you.
Who's like next?
Judge, if we can call Mr. Michael Sprouse.
Michael Raymond Sprouse, CR 2317 for docket call. Good, Mr. Manning.
Yes, Judge. Apologies, hold on one moment. Judge, we were just recently given an offer for time. And I spoke to my client on Saturday about that offer. We came up and visited, discussed some of the offers that were made. He asked me to counter that offer, and I spoke to the prosecutor in this case, Mr. Hernandez. Mr. Hernandez indicated that he was unwilling to consider the current information that I provided as mitigation. However, my client would like for me to follow up with an additional witness that I was unable to get a hold of due to an incorrect phone number before we announced ready for trial. So I asked the indulgence of the court for one more setting so that I can get a hold of this witness with the now correct number and see about if Mr. Hernandez would consider that mitigation.
State have any objection?
No objection, Your Honor. I guess short continuance sounds like it would be in order.
All right, court will set Mr. Sprouse for final docket call. 2 weeks enough time for you, Mr. Manning?
Yes, Judge. If we want to do it on the 5/20 date, that'd be fine.
Or 5/16?
Is that what we did, Mr.? Oh, I'm sorry. Yes, 5/16.
Yeah, 5/16 Thursday. All right, Mr. Sprouse, you're set for Thursday, May 16th.
Yes, sir.
All right, who's next, Mr. Manning?
Judge, next, I guess we can call Mr. Bobby Shaw.
All right, this is cause numbers 2024-11 to CR 23-118, CR 24-29, CR 24-30. State of Texas versus Bobby Jean Shaw. I believe they were set for pretrial in all those cases.
Yes, Judge. At this time, we have no contested pretrial on those cases as they stand. However, Judge, I would ask. My understanding is that Mr. Shaw was picked up on a charge this morning. He hasn't been arraigned on that charge at this point in time. And so we would ask, I guess, for a short reset to see what's going on with that.
I'm gonna go ahead and set you to docket call, but I'll allow, if there's another case that's indicted, I will obviously allow that case to catch up to these cases.
Thank you, Judge.
All right, then court finds there are no contested pretrial motions in these cases. Okay, the court sets Mr. Shaw for docket call. Let's set that a little further out to give you and the state time to ascertain the new case. I'm sure they've not received that confidence. So let's look something like June 13th.
Yes, Judge.
All right, court sets Mr. Shaw for docket call June 13th. If Mr. Shaw makes bail, then his hearing will be, of course, in the morning at 9 a.m. If he stays in custody, then it'll be at 1:30.
Yes, Judge.
And Your Honor, state had filed a motion to hold bond insufficient. I wasn't sure if the court had ruled on that motion yet.
Don't believe that I have. Let me double check. When did you file that motion, Mr. Harwell?
Let me double check, Your Honor.
Did you file in all cases or just one case?
I may have only filed it in one, Your Honor. Looks like April 11th, in CR 2430.
Mr. Manny, did you receive a copy of that motion?
Judge, I don't, I received some information, but I don't. If I may have just a moment, I don't know if I received a motion.
Yeah, they have you listed on the automated certificate of e-service.
Judge, I know I received several emails from Mr. Shaw. One was from the pretrial release officer. Judge, what was the date on that?
April 11th. Here's the motion.
And I believe it was the same date that the pretrial release officer emailed all the parties.
Yes, Judge, I believe I have that same information, at least in the exhibits. I haven't looked at the motion that's been filed, but I do have the exhibits.
All right, well, I'll tell you what, we'll recall Mr. Shaw, give you a chance to look over that. And we'll take up the motion to find bond insufficient. We'll take that up here in just a few minutes at the end of the docket.
Thank you, Judge.
You ready on anyone else?
Judge, I have possibly one more. And then I'm waiting on paperwork from Mr. Bieber.
Okay.
Your Honor,
Yes.
okay, Linda Delaney has completed her paperwork for a court-appointed attorney, and I request that we appoint the Honorable Jonathan Manning.
I think I already responded to your text message with the,
No, I saw that.
so I'm good with that.
Okay, so we're going to reset. Mr. Manning.
Yes, we can reset Miss Delaney then for. Let's set her for. Set her for May 30th. And then if Mr. Manning needs more time, we can reset after that as well.
That's the correct that I printed out, so you may have the other, the old, let me, where's that, I don't know, I don't know.
Everybody else is good to go. Okay, except Mr. Beaver and Mr. McCormick. Yeah, oh, no, sorry. Yeah, he has to say. Okay. Give me just a second. You went to sign it. Judge, if I may just have a couple minutes to go over the paperwork for Mr. Beaver.
Sure. Court's gonna stand in recess for 20 minutes.
Thank you, Judge.
And go ahead, during your recess, if you have an opportunity, go ahead and have your review with on that motion to find bond insufficient too.
Yes, Judge.
All right, court's in recess for 20 minutes. Are you unmuted, Mr. Manning?
Yes, Judge.
Okay, who are you ready on?
Ready on Ms. O'Pry?
All right, this is cause number CR 22-280, State versus Miranda Jill Opry, and we are set on the motion to revoke. Go ahead. Mr.
Judge, I've spoken with Ms. O'Pry about her motion to revoke, I believe that was on Saturday. She has tasked me with getting some documents. I've sent off for some medical records. And so we request to be set on the contested docket for the next month, just with the understanding that if I haven't gotten those documents, we'd ask for additional sitting after that.
Next evidentiary motion to revoke date would be May 30th.
Judge, yeah, if we can set it for May 30th, that would be good.
Okay, court sets Ms. Opry for motion to revoke hearing May 30th at 1:30.
Yes, Judge. Next, ready on Ms. Yao.
State versus Jennifer Danielle, CR 24-87. Are we going to plead Ms. Yao today?
Yes. Well, Judge, I had been unable to speak to Ms. Yao as she was being housed somewhere else. I did not receive any offer on her case or was not aware, but it sounds like she's requested an offer to be made and to plea on her case. I was made aware of that recently.
So, but we're just ready for arraignment today is what you're saying?
Yes, Judge.
All right, go ahead on arraignment.
Judge, if we could pull up the indictment.
I'm indicted as far as I know. I don't believe I'm indicted. I'm trying to plea out unindicted. That's the whole point of it. Yeah. I signed for 15 in Henderson County, and I was gonna go ahead, if they would give me 15 or less here, I would sign today. Because I don't wanna go to prison and have to come back. Seems like a lot of money for the county to come get me for no reason. Unnecessary. So Mandel over 400.
And Judge, I did receive a letter on the April 25th from the court, copying both the DA's office and then forwarded to me requesting that she receive a plea offer, and I believe the response was in the affirmative, but I do not have paperwork at this point in time.
So it looks like there is no indictment. It's just an information.
Okay.
It's my habitual charge. I'm sorry. It's the reason I was trying to do the unindicted plea.
Yeah, so there's no indictment in your case. What's appearing before you now, Ms. Yao, is an information filed by the Criminal District Attorney's Office alleging a second-degree felony offense with a punishment range of not less than 2 or more than 20 for possession of a controlled substance in penalty group 1 between 4 grams to 200 grams. So let Mr. Manning counsel you on that. So obviously we can't go forward on arraignment on an information because this is a felony and there's no indictment unless there is a waiver of grand jury waiver of indictment and desire to move forward with a plea on an information.
Judge, I believe based off of what my client has said today, as well as her communications with the court, that's her desire. As I said, when I came on Saturday, she had not yet been transferred here for me to discuss if that is still what she wanted to do and make sure that was that she understood what that would entail going forward.
Well, the state has filed an information, so I guess there was some desire to do that. That was that was done back on April 25th, same day that you got appointed, so I'm not sure. State, do you want to be heard on this?
Your Honor, I recognize my signature on it. I believe the information was brought to me to get filed. I'm not 100% sure what the status of the case is. If the court could give me just a few minutes to see if I can get caught up.
Go ahead.
Judge, while he's doing that, just in terms of, since Ms. Yao has confirmed that she does wish to go forward, and it sounds like the DA's office may be amenable to that, since they filed the information, when would be the earliest we could come back to take care of Ms. Yao?
I should be going to prison by the 23rd. I just was gonna.
The 16th.
16th? Okay,
That's our next criminal docket. We have a criminal trial next week. So we could possibly squeeze her in sometime next week, but it'd be before or after trial.
would it be possible to do that on Monday while they're waiting for some portion of the jury selection process? Or whether that's the list or something otherwise?
Let me talk to the state because they're a vital part of this, so I don't want to speak for them.
Okay.
So I want to have their, I don't have a problem doing it, say Tuesday morning before we bring the jury in. Monday is too hectic with the jury panel coming in, and I've already got family law settings and stuff after jury selection. Monday's too hectic.
Yes, Judge.
Tuesday morning, between 8 and 9, there's a possibility we could do that, but I don't want to interfere with the state's trial preparation either, so let's let Mr. Hartwell get back and we'll figure out.
Yes, Judge.
Go ahead and have a seat, Ms. Young. We'll bring you back.
Thank you, sir. I appreciate you.
You have anyone else, Mr. Manning?
Judge, I believe Ms. Taberham reached out. Something.
All right, we're back on the record. Go ahead, Mr. Hartwell. Anything you found out?
Yes, Your Honor, we're good to go ahead and set that on Tuesday and set for plea for the 15 TDC.
And do it prior to the jury coming in?
Yes, Your Honor. And just for purposes of the record, we would write that to be concurrent with the Henderson County.
All right, you said for 15 years?
Yes, sir.
Okay.
And Judge, based off my conversations just with my client recently, I believe that's something she'd be willing to accept. I would ask though that the state release any discovery they do have, so I can do a pre-indictment review of that. To make sure it's legally sufficient.
And I did just send it. It should be ready to go. That was one of those issues with LGS that I was mentioning earlier today is it's been a little bit late. So if you don't have it, let me know and we'll get you in front of a computer to review it.
Awesome, thank you.
All right, the court will set Miss Yao for plea before the court on Tuesday, May 7th at 8:30. We'll do that before the jury trial resumes. And so just a reminder, we'll need to have a waiver of grand jury waiver of indictment form for Ms. Yao for that date.
And Judge, what time was that again?
Let's do 8:30 on Tuesday, May 7th.
Thank you, Judge.
That's next Tuesday.
And Miss, yeah, be excused.
Yes, we'll see you next week.
Appreciate you guys.
Judge, next, I think we're ready on Mr. Beaver.
All right, Mr. Beaver, if you'll come forward. This is cause numbers CR 2287, CR 24-1, State versus Gregory Alton Beaver. Mr. Beaver, is he still playing today, Mr. Manning?
Yes, Judge. And Judge, just, there's been a couple of different itinerations of paperwork, so just let the court know on CR 2287. That is a motion to revoke. The state has agreed to abandon counts 1, 3, and 4, and upon a plea of true, the state's motion to revoke. The agreement is that his community supervision be revoked, punishment assessed at 5 years confinement in TDCJ, balance of financial obligations. His fines on that are $2,225, $0 court cost, $0 restitution, and $85 reimbursement. Furthermore, he has 230 days credit.
So he's going to be pleading true to 2 and 5, counts 2 and 5, or 2, 5, 6, 7, 8, 9, and 10.
2, 5, 6, 7, 8, 9, and 10.
Okay. What about CR 24-1, unlawful possession of firearm by a felon, 3rd degree, 6 years TDC, no fine, no restitution, $75 reimbursement fees, $290 court cost, and $12.45, a bunch of unfiled DA cases.
Judge, with one exception, it's going to be 5, not 6.
Okay.
And we are going to 1245, 7 other unfiled, rejected case numbers.
199 days jail credit.
That's correct, Judge.
All right, Mr. Beaver, sir, if you'll raise your right hand, I'm gonna place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you, sir. You can lower your hand. All right, let's see. Your name is Gregory Alton Beaver, correct?
Yes,
And Mr. Beaver, you're a United States citizen who reads, writes, and speaks English, correct?
yes,
And in this case, both of your cases, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's representation of you?
yes,
Like you've had enough time to talk with him about your cases to the point you've had all your legal questions answered?
yes,
Anything that you don't understand about your plea agreement?
no,
And have you ever been diagnosed with any type of mental condition?
no,
All right, Mr. Manning, do you believe that Mr. Beaver is competent to enter into these agreements? And if so, that he's doing so intentionally, knowingly, and voluntarily after you explain to him his legal rights?
Judge, I do believe he is competent. I do believe he's entering into these intentionally, knowingly, and voluntarily.
All right, Mr. Beaver, in the newly indicted CR 24-1, you are charged with unlawful possession of firearm by a felon, a third-degree felony that does carry a range of punishment of not less than 2 years or more than 10 years confinement in prison, and a possible fine not to exceed $10,000. The plea agreement in that case, as we've read into the record, is that upon your plea of guilt, states recommending that you be convicted of that offense, that your punishment be assessed at 5 years confinement in the Texas Department of Criminal Justice with $290 court costs, $75 reimbursement fees, and also 199 days credit towards that sentence for the time that you've already spent in jail. And the court would be dismissing several unfiled cases that the DA's office has not filed to resolve all of your business here in Van Zandt County. And that sentence would run concurrent with your sentence in cause number CR 2287. In CR 2287, in which you were placed on community supervision upon your plea of true to the counts that were not abandoned, the state is recommending that your community supervision be revoked and that you be sentenced to 5 years confinement in the Texas Department of Criminal Justice with the balance of your financial obligations, which includes a fine and reimbursement fees. Those sentences running concurrent with one another. Is that your understanding of the plea agreement, Mr. Beaver?
yes,
All right, then, Mr. Manning, does Mr. Beaver waive the formal reading of the state's motion to revoke?
He does, Judge.
All right, so Mr. Beaver, in CR 2287, in which a motion to revoke was filed, how do you plead to counts 2, 5, 6, 7, 8, 9, and 10? Are those counts true or not true?
true,
And you're telling me that those counts are true because in fact, what is alleged is in fact true.
yes,
Is that right? And Mr. Beaver, has anybody threatened, forced, or pressured you to plead true to the counts?
no,
All right, and in the newer case, CR 24-1, how do you plead to unlawful possession of firearm by felon?
guilty,
You're also pleading guilty to that crime because you are guilty of that crime, correct?
yes,
And no one's threatened, forced, or pressured you to plead guilty.
no,
All right, and Mr. Manning, is there any objection to the stipulation of evidence in the unlawful possession of firearm case, or any objection to the admission of the defendant's waiver of rights and plea of true in the theft case?
Judge, the only, and it's not a substantive correction, but the only correction that we would make is in the new case, the CR 24-1 case, the stipulation of evidence says that Mr. Beaver was the only had the only key to access that building. There was a Miss Tankersley that had a key to access that building. Other than that, we do recognize that he was in possession of the firearms, and plead true to those. I mean, guilty to those.
All right, there being no objection, then the stipulation of evidence is admitted and the court takes judicial, and also the defendant's waiver of rights and plea of true is admitted into evidence. And the court does take judicial notice of the defendant's pleas of true and the defendant's plea of guilt. Is there anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
No, Judge.
All right, Mr. Manning, I don't believe that I have the stipulation of evidence in the CR 24 case. Let me double check. Can you either read that or place that in front of the screen? All right, thank you, sir. All right, the court has reviewed the evidence. Court finds that there is sufficient evidence to convict Mr. Gregory Alton Beaver of unlawful possession of firearm by a felon. The court follows the plea agreement. Upon his conviction, the court hereby assesses punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division. Orders him to pay court costs of $290 and reimbursement fees of $75. The court awards him 199 days credit towards his sentence for the time that he spent in jail on that cause. In addition, the court does take into consideration and dismiss unfiled DA cases of possession of a controlled substance, burglary of a building, theft of property, burglary of a building, theft of firearm, fraudulent use or possession of identifying information. In cause number CR 2287, upon the defendant's pleas of true, the court finds that Mr. Beaver has violated the terms and conditions of his community supervision. The court follows the plea agreement, revokes his community supervision, assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice. Court also orders him to pay the balance of his financial obligations and awards him 230 days credit towards his sentence for the time that he spent in jail on this cause. Court hereby orders Mr. Beaver into the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentences. Mr. Beaver, I'm going to have you step over to be fingerprinted with the deputy. Once you get out of prison, if you've not paid off your fines and fees, you need to report to the courthouse or the clerk's office and make payment arrangements, okay?
Yes, sir.
Who else are you ready on, Mr.
Judge, ready on Mr. Shaw.
Before we go any further, Mr. Manning, will you look back on Mr. Beaver's judgment revoking community supervision?
Yes, Judge.
And so it does say 5 years in the punishment in place of confinement. Punishment be assessed at 5 years. Is that correct?
Yes, Judge.
Okay, all right. Just want to make sure. Okay, thank you. All right, Mr. Shaw, come on up. All right, Mr. Hartwell, this was your motion to find bond insufficient. You may proceed.
Yes, Your Honor. At the docket on March 23rd, the court ordered Mr. Shaw to take a UA. Mr. Shaw complied and took that UA. It showed positive. Mr. Shaw assured the court that it was a false positive. It was sent off for testing on April 4th. The state received an email from Todd West with the lab results that show that it was in fact positive for methamphetamine. State also received information that Mr. Shaw was arrested on or about April 5th for another criminal matter in violation of his pretrial supervision, which was signed on June 20th of 2023.
Are you offering evidence to the court?
Yes, Your Honor. I would offer attached to my motion labeled as Exhibit A are the lab results sent to the state, the court, and defense from Todd West. State would offer those lab results as Exhibit A.
Any objection from the defense?
Judge, we just object to authentication and to hearsay.
All right, court's gonna overrule those objections and Exhibit A is admitted. Do you have any other evidence regarding your other allegations regarding the arrest?
I do not, Your Honor, because of its recency, I don't have a report yet. So I would let that stand on just the information that the state's received. But I would have a request that I believe it's Tiffany Shaw may be a victim, and state would request that in any event, the court add no contact orders to all of Mr. Shaw's conditions of probations with Miss Tiffany Shaw, due to the fact that she is a potential victim in that alleged offense.
What's the date? If the one I got arrested for today, what the, it's in the contact date.
All right, anything further, Mr. Hartwell?
No, Your Honor. Thank you.
All right, Mr. Manning, anything for the court?
Judge, I don't believe there's been any evidence offered that Ms. Shaw was a victim. Furthermore, the allegation is that the alleged crime that he's been picked up on, this new crime, is a criminal mischief. I would just note for the record that Mr. Shaw was previously picked up for criminal mischief before, and so I haven't heard any evidence that delineates this offense from being a different offense than what he was previously arrested for. I'd be interested to see if there was a revocation of bond or any other type of bondsman going off his bond on that. In regards to the test, my client maintains that he has not ingested, injected, swallowed, or snorted or smoked what's being returned as methamphetamines in his lab reports. And so for that reason, we'd ask the court to maintain his bond as currently set.
All right, so all right, based on the evident arguments of counsel, the court's gonna find that Bobby Jean Shaw has violated terms and conditions of his community supervision. The court finds that Mr. Shaw has tested positive for a controlled substance. Court hereby finds that Mr. Shaw's previous bond, which I believe was $100,000 personal bond, is insufficient. And the court hereby sets bail at $100,000 surety in cause number CR 2430.
Judge, if I may have a moment just to speak to my client.
Yes, let me make one more announcement with regards to the state's request regarding victim conditions. The court not having any evidence upon that today in this hearing, that matter will be taken up either by the magistrate who receives any information upon the magistration process, or at the time that Mr. Shaw's indigency information or conditions of pretrial release are presented to this court. Go ahead, Mr.
I'm sorry, Your Honor, if I may, in the indictment for the arson, Ms. Shaw is the listed victim in the arson case.
And so are you saying that the conditions of pretrial release don't account for that at this time?
Yes, Your Honor.
Judge, at this point, there's been no allegation before the court of any behavior that would warrant such a no contact order with Ms. Shaw. And so for those reasons,
I think,
Oh.
gentlemen, that it's a moot point because I believe that these were signed by me back in March and boxes 4 and 5. If Ms. Shaw is this alleged victim in this case, then she is protected by condition 4 and 5 already.
Which case is
Okay.
it, Judge?
Arson and evading arrest,
Okay, and when were those conditions signed?
March 13th
Of 23?
last year.
Thank you, Judge.
Thank you, Your
okay,
Honor. I
so-
must have gotten it confused with another case.
Sorry.
Judge, with the court's ruling in this, my client asked that his other personal bonds be found insufficient and that all his bonds be revoked so that he may get credit for time while he's sitting here in jail on this charge of waiting for trial.
All right, Mr. Shaw's motion is granted.
Thank you.
Judge, I believe that concludes our business. May he be excused.
Yes, thank you. We'll see you back on June 13th. So do we only have Mr. McCormick left?
Yes, Judge. And I'm just waiting if I can have the courtroom cleared before we plead Mr. McCormick.
All right, go ahead. Ready, Mr. Manning?
Yes, Judge.
All right, this is cause number CR 23-188, State of Texas versus Marty Glenn McCormick. Mr. McCormick, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Your name is Marty Glenn McCormick, correct?
Yes, sir.
And Mr. McCormick, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with a mental condition?
Depression.
Are you currently on medication or under a doctor's care for depression?
Yes, sir.
Mr. McCormick, do you feel like you have a rational understanding of the proceedings as they are occurring today?
Yes, sir.
And in this case, Mr. McCormick, you have an attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the legal work he's done for you?
Yes, sir.
Is there anything about your plea agreement and the paperwork that you signed today that you do not understand?
No, sir.
Mr. Manning, do you believe your client to be competent?
He is, Judge.
Have you explained to him his rights as they pertain to this case?
I have.
And do you believe he is entering into this agreement intentionally, knowingly, and voluntarily?
I do.
All right, Mr. McCormick, you are charged with a third-degree felony offense of online solicitation of a minor that does carry a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and a possible fine not to exceed $10,000. I see the plea agreement in your case is upon your plea of guilty to that crime, the state's recommending to the court that the court convicts you of that offense and assess your punishment at 6 years confinement in prison with $290 court costs and $35 reimbursement fees, with you also receiving credit of 94 days for the time that you've already spent in jail on this cause. Is this your understanding of the plea agreement?
Yes, sir.
All right, understanding all of that, then Mr. McCormick, how do you plead to online solicitation of a minor?
Guilty.
And are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
And Mr. Manning, any objection to the stipulation of evidence?
No objection to state's one.
All right, court does take judicial notice of Mr. McCormick's judicial confession, accepts his plea of guilty at this time. Court admits the stipulation of evidence into evidence. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Nothing from defense, Judge.
All right, court's going to review the stipulation. All right, upon the court reviewing the evidence, the court finds that there is enough evidence to convict Mr. McCormick of this offense. The court does follow the plea agreement today and the recommendation of the state. Court convicts Marty Glenn McCormick of online solicitation of a minor, a third-degree felony, assesses punishment at 6 years confinement in the Texas Department of Criminal Justice, orders him to pay court costs of $290 and reimbursement fees of $35. And the court awards Mr. McCormick 94 days credit towards his sentence for time he's already spent in jail on this cause. Mr. McCormick, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. Good luck to you, sir. Mr. Manning, is there any further clients of yours?
Judge, I believe that's all I have. Would reiterate, we've gotten copies of that judgment for Johnson County. And those are going back with Ms. Abraham. On the last page of the judgment where the judge's signature is, it does show that the fines, the court cost and other financial obligations that were owed in Johnson County were waived as time served. So for Mr. Ehrenfeld, if you'll just take a look at that once that's provided to the court.
Well, what I'll do, Mr. Manning, as an officer of the court, I'm going to take your word for that, and the court will grant Mr. Ehrenfeld credit for the time that he's been in jail towards his fines and court costs, so long as it's not restitution owed. If it's just a court cost or reimbursement fee, court will award Mr. Ehrenfeld $100 a day credit towards those.
I appreciate that, Judge. I know he will as well.
All right. If one of y'all can relay that message to Mr. Ehrenfeld, I appreciate it.
Thank you, Judge.
All right, Mr. Abraham, is that all we have in the jail today?
Yes, sir. We'll see you back in a minute.
Hey, you can quit faking. If you want to be off tomorrow, just tell me you want to be off tomorrow. You don't have to do that fake sick thing, okay?
Yeah.
All right. We are adjourned for the day.